expeditious disposal of our disputes. We are seeking for harmony among ourselves as communities and also as business people. Under the social transformation through access to justice, we are promoting the uptake and utility of arbitration, mediation, and alternative traditional justice systems and other innovative mechanisms to power our quest to deepen access to justice for all. We recognize that different disputes require different solutions and that one size does not fit all. We are therefore committed to providing a variety of options for litigants to choose from depending on their needs, depending also on their preferences and circumstances. The menu is on the table for people to choose. We are also committed to ensuring that these options are available, they are affordable, they are accessible, and they are acceptable. And beyond, they are appropriate for all the segments of our society. This multi-door approach is not merely a symbolic gesture. It is a pragmatic strategy designed to expedite the dispensation of justice, designed also to make it more affordable, and above all, to enhance accessibility. By welcoming arbitration, mediation, and traditional justice systems into our justice delivery framework, we acknowledge the diversity of our people and respect the rich tapestry of socio-cultural contexts within which disputes arise. Our aim, therefore, is to ensure that each citizen, regardless of their social status, cultural background, or geographical location, has access to a mechanism of dispute resolution that is fair, effective, and respectful of their dignity. We are therefore tirelessly working towards a justice system where the vulnerable are not just beneficiaries of justice, but they are also active participants in its administration. Arbitration, a core component of our multi-door approach, has a unique role to play in our quest to put in place a people-centered justice system. As a more flexible, time-efficient, and even less adversarial alternative to traditional litigation. Arbitration, as we all know it, is instrumental in our pursuit of our goal of enhancing access to justice for social transformation. Arbitration enables us to expand access to justice not only to those who can navigate the formalities of the courtroom, but also to the most vulnerable who may find the traditional litigation very intimidating or financially burdensome. We are also keenly aware of the role of arbitration and other forms of ADR in promoting economic development and fostering social harmony. It is in this context that we are championing for all of us to embrace arbitration as a vital tool for resolving commercial disputes in a very fast, flexible, and cost-effective manner. By doing so, we will be enhancing an environment to conduct business which is efficient and reliable, and thereby will be contributing to attracting foreign investment. We will also be enhancing our trade relations and supporting economic growth. To speak to continental realities within Africa, I dare say that the adoption of arbitration will address some of the systemic challenges that have long plagued our justice systems. The huge case backlogs, delayed judgments, and the resultant disillusionment among citizens with the justice system can be mitigated through an efficient arbitration framework. By increasing reliance on arbitration, we can decrease the pressure on our courts. We can make our courts more efficient by leaving them free to deal with matters that cannot fall within this ambit of the multi-door approach and therefore contribute to a broader social transformation that we are all seeking. As you all know, distinguished delegates, Africa is a continent on the move. We are seeing a growing number of international commercial transactions taking place on our continent. And with that, there is a big demand for alternative dispute resolution mechanisms. It is also worth mentioning the international arbitration forms a significant part of the new era of dispute resolution in our continent. International arbitration stands at the intersection of globalization and the law, offering a neutral platform that respects the diversity of legal cultures, customs, and practices. Its potential to provide timely, cost-effective, and private resolution of disputes makes it a very powerful tool for advancing justice to all. I therefore believe that the future of international arbitration in Africa is very bright. We have a young and growing population, and we are increasingly becoming a hub for international trade and investments. This means that there will be a growing demand for ADR mechanisms in the years to come. It is in this context that Kenya has positioned itself as a regional hub for arbitration services in East Africa and beyond. We have a vibrant arbitration community comprising of qualified arbitrators, lawyers, experts, institutions, and associations. In recent years, we have also seen a growing number of international arbitrations being seated in Kenya. This is a testament to the quality of our legal system. In this regard, let me take this opportunity to assure the community of arbitrators gathered here that the judiciary of Kenya is committed to creating and supporting the arbitration practice in Kenya by ensuring that our courts respect the principle of party autonomy. Our courts enforce arbitration agreements and awards and provide judicial assistance when necessary. Part of our efforts in this regard includes working towards enhancing the efficiency of our specialized commercial division of the High Court to ensure that commercial matters, including arbitration-related matters, are determined expeditiously and competently. In addition, through the Kenya Judiciary Academy, we have also invested in capacity